A sexual harassment charge will not stick if the woman was apparently wearing a sexually provocative dress, is what a Kerala court said today while granting bail to an activist, Civic Chandran. A social activist and author, Chandran has been accused of sexually harassing a young writer at a camp in Nandi Beach on the 8th of February 2020. In his bail application, the 74-year-old Mr. Chandran produced photographs of his accuser in court. Reserving its order, the Kozhikode Sessions Court said that the woman was wearing sexually provocative dresses, so the allegation doesn't wash. This raises a lot of question marks on whether this is at all a legally tenable position by the court. We are now joined by Yogita Bhayana and Brinda Adige. In fact, let me go to Brinda Adige first. Sexual harassment doesn't apply when a woman was wearing sexually provocative dresses, quite besides the fact that I'm uncertain when, which century the court was actually, operating in. How is this entirely legally untenable by Indian law, this position?
You're absolutely right. There is no law that has such a phrase that this particular magistrate seems to have pronounced in the court. No law at all, including the law that talks about protecting women against sexual harassment at the workplace is very, very clear. The intention of the perpetrator is immaterial. And if the woman has felt that her modesty has been outraged and a committee has looked into something like this, it is but important that the law is taken into consideration, not patriarchal, sexist, chauvinist mindsets. This is exactly what we have seen over there. And perpetrators gain impunity when such orders are given by judges. Magistrates.
The court says that the wording of section 354, you were referring to that, is very clear, and that there must be an intention on the part of the accused, in other words, in this case this man, for outraging the modesty of a woman. Apparently in this case that intention was not there.
But there is nowhere in that jottings how the judge arrived at such a conclusion.
Yes.
A. B. He also has to look at this particular offender, perpetrator, has two other cases against him on similar sections. So is that not something that the judge or a magistrate and the public prosecutor will take into consideration? That is an important aspect. Whether he was acquitted or not is secondary. But such a complaint from two different other women. And that is exactly what my court is for.
Sure. Brinda, my only assertion over here is that rather than look at this individual case and judge the merits, in terms of our conversation, that's very easy to do. I think it's more important to actually look at what the court said. And I'm just going to take our conversation back to that key point. Sexual harassment complaints will not prima facie stand when a woman is wearing sexually provocative dresses. Because this is more than just this one particular case, right? As demeaning as this case may be, when a judge actually says this, it has an impact on the judiciary, right? Unless it's challenged and it goes forward. And therefore, isn't that the worry, that this represents a deeply sexist mindset? And if it comes at the level of a court, then the process of justice is subverted.
Yeah, absolutely. This is a deeply patriarchal, sexist mindset. It is not just this magistrate and not just the court, but we are seeing something like this across strata, across the various systems. If there are times when we have police who have behaved like this, we have elected representatives who have spoken like this, and blaming the attire of the woman for a crime committed by a man. And that is the dangerous pathway that we are all forced to actually ask ourselves. So if I was or am so-called modestly attired, am I safe from being not harassed?
Who defines modestly attired and who decides sexually provocative? It's bizarre. The idea is the safety of women. Also. The idea is the safety of the individual, right? Isn't that the primary thing which gets forgotten over here? That you can wear what you want in our country. The laws already define what I mean, what becomes illegal? You cannot be nude, for example, in certain contexts. But then to say something is sexually provocative is just sort of deciding on yourself what works for you and what doesn't.
See, that is the patriarchal mindset that blames the woman, that maligns the character of the woman, that places the onus that the woman was A, B, C, D, and so this crime is nullified, and this crime will not be punished any further. And this is so dangerous when something like this comes from the court, from a magistrate, because where else can we go if the law of the land, which has been formalized and the policies are put in place, now you want to implement it and get justice, get a result and an impact out of it. But somebody sitting up there who must be able to give us that impact decides that provocative clothing means you cannot take the support of this law.
Right.
Provocative dressing means you cannot be protected. Provocatively dressed means you are no longer a citizen of this nation who can claim any entitlements under the Constitution.
There's another part of this judgment which also needs to be looked at. The court observed that it's a well-settled principle that when there is a long delay in lodging an FIR, then the reason for the delay must be properly explained, and in this particular instance that delay was not explained. But again, isn't this problematic? The expectation that you instantly complain when there are so many factors which actually influence the timing of the decision of a woman or a man to actually raise the allegation of sexual harassment. I mean, you can complain 10 years later. That doesn't mean that your complaint is invalid. There may be extenuating circumstances. So many people don't complain.
Right. You can complain but one thing we have to keep in mind is the stipulations of your complaint. There are some complaints that cannot be taken after a stipulated time period, and that is that. But this particular complaint of this nature can be allowed in court. And that is how it was allowed in court. Otherwise, at the scrutiny level itself, it would be rejected.
Yeah.
What all of them forget or do not want to be reminded is we live in a society, we live in communities and families where women or men or trans persons will not come out immediately to make a complaint of this nature, especially sexual in nature.
Because it's extremely difficult in our system. Our system is not transparent. There are so-called social mores. There are people who discourage this sort of thing. It needs a great deal of courage, and that takes time.
It needs a great deal of courage. It needs a great deal of support.
Sure.
We need support from family and others, because you also know that the victim and the witness protection program that is supposedly to have been there for the last 8-9 years is not so strong in our country. And that is another loophole, because once I come and complain, what is the protection that might be awarded to me by the system, by the law? And that is a big, yes, it is scary, but the other is there is no support. And they are already contending with a patriarchal community and a society. And that is why we want the state to step in and change a lot of these mindsets.
That's so very important. Unless there is a change in mindsets at so many levels, in this case, in the level of the judiciary, then perhaps justice will continue to be delayed or denied. Thanks, Brinda. Lovely speaking to you as always. Thank you very much for being with us.